Elaine Fahey, Sabine Saurugger, Giulia Gentile. Welcome to Digital Markets Research Hub. We met recently at a conference co-organized by Elaine, and among the main topics which have been discussed was the issue of strategic litigation. And because each of us works at different aspects of EU law, we have agreed that this phenomenon serves as one of very few common denominators. So we observe different incarnations and different aspects of it in different corners of EU law. So we have agreed to meet and discuss informally our reflections about the issue of strategic litigation. Furthermore, you have published on this issue, so you have more structured vision on different aspects of this as well. So maybe we can start with defining for ourselves and for the purposes which we will be using the term strategic litigation in EU context. Is it an EU-specific issue, or it is common for different jurisdictions? If EU is unique, why? And so just as an introductory matter, why wouldn't we start with you, Elaine?
Sure. Thank you so much. It's a fantastic to be with you and to discuss these issues. I suppose for me, rather than speaking about the other project that we're related to, but strategic litigation, it has generally a goal, it has actions, it has a very interesting set of relationships with the bottom up and the top down. And of course, EU law has been defined for many decades by waves of strategic litigation, of specific mobilization of academics. Some of the most famous cases of all time, from Dufresne and Sabine, or Tommaso Pavone in his fantastic book has shown how so many areas of law have been mobilized in different ways, different trade unions. Nowadays, in the digital era, we see the NGOs. So strategic litigation is not necessarily something new, but it certainly is something that has defined EU law as a subject. And if you listen to people such as Koen Leonard, who talk about teaching EU law for the first time in the 1960s in Harvard Law School, when there was no litigation and they were just learning about the articles of the treaties, we have come a very long way. But in a sense, EU law has always been about some form of strategic litigation. And I think a lot of political science work now, there's some fantastic work on the digital era about civil society mobilization and the transnational, but I suppose we could also take the view that it's not per se, earth-shattering or really absurd to suggest that EU law has been very much defined by a set of interest group political scientists. Lawyers have united over these ideas over a long period of time. So that would be the starting point I would come to and say, it is something that I think unites us all very well across subjects and disciplines, and it is in fact something that has much historical reference, as people such as Tommaso Pavone have shown.
Many thanks, Elaine. Sabina, would like to add your vision on this phenomenon?
Yeah, thank you so much. And again, like Elaine, I would like to thank you for organizing that, because it's a fantastic opportunity. I'm a political scientist, so therefore my view might be sometimes a little bit different, but here I entirely agree with Elaine when she says that the strategic litigation is a feature of European integration that exists for many years. It is not specific to European integration, and we know that for example, Dan Kellerman has extensively published also on this issue, in calling it Eurolegalism, and a number of other colleagues, sociologists, have worked on the fact that we have a sort of market developing for legal scholars and for legal experts. Big firms that are active in strategic litigation, that represent different private firms, but also NGOs, and therefore there is really something that defines the production of law, not only at the European Union level, but also specifically at the European Union level, I would say.
Many thanks, Sabine. Giulia?
Thanks, Oles, and thanks for having me, and great to be here with such great colleagues. I won't add much, apart from the fact that there is, of course, an attention to strategic litigation in the EU because of the focus on rights. So the idea that rights can be, so to say, used or almost weaponized, perhaps we could say, in the context of, we can say, litigation to pursue certain objectives. And the narrative around rights in the EU has been quite powerful since the beginning. And the work of Arena, but also Passalacqua, Arena on Costa versus Enel, and Passalacqua in the context of migration, really show the power of rights. So I think that so long as we have rights that can be operationalized through the through judicial interpretation to judicial enforcement, we will have a certain degree of strategic litigation. And the EU, I think, is a prime example of this dynamic.
Thank you, Giulia. My next question is somehow linked to the first one, and namely, we hear a long range, if we bother to search, defining a phenomenon which is kind of similar. So you mentioned, Elaine, already, mobilizing the law, focusing or accentuating stress and using it opportunistically. So I imagine the shades of this color might vary significantly. And from normative perspective, or kind of assessing axiologically the role of this reality, essentially. So how can we define maybe the issue of strategic litigation from the opposite? How can we look at it by figuring out what it is not, so to say?
Yeah, great question. It's very early in the morning to give you a really good answer. That's an interesting perspective. I would maybe start from the perspective, I'm still working through this, so I don't have a brilliant answer for you. It's very worked out. But one thing that really strikes me is how open the EU legal order is to all kinds of interests. From Venezuela, Russia today, the US commenting on the GDPR review. There's no shortage of the EU's friends, foes, allies having possibilities to engage with the EU law, right? So, and mobilization is a very broad term, and also strategic litigation is not something that has per se a definition in EU law, and it is now part of Article 80 in the GDPR. And people like Max Schrems were iconic and litigating the definition of the consumer under the Brussels regulation before the advent of the GDPR. So there's a long trajectory there, but if you just pause and say the broad question when we speak about mobilization and strategic litigation as if it's something far-reaching. Well, the EU legal order itself is a very broad church. It's very open. It has a huge enforcement regime. It has a very wide, multi-faceted, multi-layered set of engagement or entry points. And it's no surprise, perhaps, that the GDPR follows that. And it's no surprise, perhaps, that it plays out in other ways. So that would be the starting point. I would say that the EU legal order itself has, in primary and secondary law, a set of constructs that are there, or an infrastructure, and that its openness is quite remarkable and important. And data is, I think, Giulia just mentioned some literature that's spanning other topics, migrations, many other fields of law that are equally benefiting from those ideals to a degree, however we might frame it.
Yes, thanks a lot, Elaine. Sabine, how do you evaluate it? Is it a positive phenomenon, or something which we have to appreciate, or something which we have to be mindful of, or with higher risk level?
I wouldn't situate myself on this normative ground. I feel this is part of a development of a fact that we observe in political systems. And I think your question is super interesting because you asked the question, what is not strategic litigation? Okay, we've talked about strategic litigation, and it's everywhere, but I really think and you are absolutely correct, we need to be more precise. For me, in the field of work that I do on the link between interest groups and the court, I see strategic litigation as the use of judicial procedures for a specific cause. So it is not every and each case that is strategic litigation, but there is a strategy behind it, and the strategy is much broader than the single case that is brought before the court. And therefore, what we see, and in political science, we can distinguish between two types of strategic litigation. One is a proactive litigation, where the cause is defined from the outside, and then it is brought, the court is called upon to decide, or we do have a preliminary rulings procedure that leads then to court decisions. And the other one is also a type of strategic litigation, which is reactive litigation. Therefore, having an actor actively ignoring a legal framework and making sure that they are condemned by the court for not accepting and not observing a rule, and therefore then using this this situation to for strategic litigation afterwards. So I really think that we need to be more specific, and you are absolutely correct in reminding us to do so.
Many thanks, Sabine. Giulia, how do you see it? And maybe given your juristic background, connecting it with more traditional legal techniques of delaying or refocusing judges' attention. So the phenomenon of strategic litigation is slightly different. Yeah, it's not purely juristic technique.
Yes, I agree in the sense that I share all the views of Elaine and Sabine, in the sense that the line sometimes can be quite blurred, so it can be quite challenging to identify what is strategic and what is not, because as a matter of fact, all litigation is strategic, right? In the sense that it is grounded on judicial strategies and techniques. But I think that if I had to try to distinguish what is strategic and what is not strategic, I think that there might be perhaps three features. So first of all, I think that strategic litigation has to have a certain degree of novelty. So it must be something that it is quite, so to say, groundbreaking, in the sense that it fosters some, it brings to the fore and sheds light on some interests or rights that until that point in time were not fully acknowledged, were not fully perhaps developed or embedded in a legal order. And this brings me to the second point. It must have some form of creativity, right? It must be, I'm thinking, and these features are really drawn by cases such as Costa versus Enel or the Schrems saga. They bear some level of creativity. This wasn't done before. And it's also quite creative from the perspective of how legal arguments are built and brought. So there must be also some level of creativity. And I think that the final attribute that I would give to strategic litigation is that it should be forward-looking. So it wants to bring, and this is something that was mentioned before by Sabine and Elaine, it must be, so to say, future looking, forward-looking, in the sense that it wants to bring a legal change in the legal order through judicial interpretation and through judicial enforcement of the law. And this change should have some form of systemic, I think, implications. One can say that all litigation can have these features, and I fully agree. But I think that the combination of these three elements probably could perhaps help us narrowing down what is strategic litigation and what is not. But so to say, a theory to be tested.
Thank you, Giulia. Elaine, you mentioned Tommaso Pavone, and I'm thinking that so if we trace the evolution of strategic litigation, we can refer to cases mentioned by Giulia and Sabine already. So those which are kind of Christomatic cases, which we all study when approaching EU law, and we can somehow maybe metaphorically say that this layer of cases, or in this period, were about self-establishing EU law vis-a-vis the robust, mature legal systems of funding member states and member states more generally. So that was kind of legal autopoiesis of EU law itself. Then it evolved into something slightly more nuanced, I imagine. Yeah. So that nowadays it's not about the trajectory of the relationship between EU law and the law of member states is only one of possibilities for shaping EU law, so to say. What, in your view, how can we trace the evolution of it from 1970s to 2020, so 50 years pretty much?
Yeah, so great question. I'm not sure I have all the answers. I think there's a very rich historical set of accounts emerging that answer that point. But I think it is clear if you look at the empirical work that's being done that the geography matters, the clustering of expertise and lawyers. So we see this now in the data era, the one-stop shop. It's no accident that Dublin is a very key strategic leaping point for NGOs or for people like Max Schrems to locate those who are able to initiate the legislation. I think more broadly, I would say strategic litigation has to be about being interest-driven and subjects and objects, and initiating change and understanding the change that happened through the earlier cases, let's say Dufresne and Sabine and so on. It's those are really long-term projects of lawmaking, policy making to see impact. I think we see much more short-term, easier impact to chart in the data time. So I'm not so sure. It's a very difficult set of things to you're not comparing like with like. And I think one joke that criminal lawyers make about organized crime, and they say, it's usually disorganized. And I would say strategic litigation, I would probably try and make the same joke about it. My take on reading so much about strategic is that it's usually quite unstrategic, and that it accidentally interests do align, or that experts do latch on to the fact that people such as Max Schrems and NYOB are taking interesting cases. Lots of really smart kids from the EY turned up in Brussels or during lockdown to find out, so don't count kind of the practicalities and geography as being a very simple thing in a transnational sense. There still is a very local dimension to all of these cases, and it's no accident that is it Elaine Fahey, like a very leading experts on, let's say, equality and so on, that they all kind of clustered together. So we can try and put academic niceties on it, but practicalities do become important in strategic litigation, how outcomes emerge. So,
Thank you, Elaine. Sabine?
Also a very relevant question. Did strategic litigation change since the 70s? And Elaine has already answered that sometimes litigation is also unstrategic. But I do believe when we look at the empirical evidence, and this comes back to Giulia's definition, is that strategic litigation takes place when a new policy area, a new policy field is attracting attention. So, for example, when we look at equal rights, there is very limited strategic litigation today in equal rights, in the field of equal rights. This doesn't mean that everything has been covered, but strategic litigation is used to create something new. Not only it is a novelty, but it is also used to create new policy making in specific fields. So this is why, for example, the Schrems cases, which are two consecutive cases, is strategic litigation in the sense that there was really very little regulation on this particular field, and therefore strategic litigation was used to push regulatory activity forward. And I think this is something that we see. I'm not sure whether the litigation as such changes, strategic litigation as such changes, but it occurs when a new policy field emerges. Taxation is another one. And here actors, use the traditional power of courts strategically, as I would say so.
Thank you, Sabine. Giulia, how do you see this aspect?
That's a very good question, and in a way links to the point that you raised earlier on. How do we distinguish what is strategic and what is not, and how do we embed this in historical structures and evolution? I think that the substance of strategic litigation, so to say, hasn't really changed, in the sense that the so to say, the objectives that may be pursued through strategic litigation, of course, depend on the field of law, as both Elaine and Sabine have mentioned. But I think that what has changed is the context in which strategic litigation occurs, in the sense that we have legal orders in the EU as well, which are becoming increasingly complex. So the reality is that when we try to pursue through litigation specific interest, it is inevitable that those specific interests or rights may conflict with others. So I think that what has changed is not really strategic litigation per se, by the way in which courts need to approach strategic litigation because of the different interests. And this is one aspect. And then the second aspect is empirical, I would say, in the sense that what we see globally are cuts to legal aid, cuts to and limitations, I would say, to access to courts. So in many legal orders, we can identify hurdles and challenges to access courts. So perhaps challenges and around the ability to have a claim heard by a court are higher nowadays compared to the past, but with the due differences and the due of course specificities of each context. So I think these are contextual changes rather than substantive changes, I would say.
Thank you, Giulia. Elaine, we hear Sabine and Giulia referring to the Court of Justice as an actor in these processes. And so how do we, I imagine there must be quite a rich literature, socio-legal, and maybe political science, Sabine, as well, examining what we have the vocabulary in digital market, the posture of enforcer. So I wanted to extrapolate it, maybe the posture of the judicial authority. Are they mindful of the implications of the judgment which they deliver, implying that they will have such strategic implications or consequences? Do they have to be mindful? Do they have to be still familiar with blind eyes and addressing the case, examining the case inductively, focusing only on the facts rather than on broader implications? What is the state of affair in the role of the court in these processes, in your view?
Thanks, Ola. It's the million-dollar question. Well, what does the Court of Justice think? The most important question of all. I would start by turning the question a little bit around and say that one thing that interests me very much is how some other institutional actors in the EU don't litigate. For example, the European Parliament rarely litigates, and some of the most important data transfer cases that the Parliament has litigated, it's usually been one parliamentarian litigating on her own. She was part of the Libe Committee, the Civil Liberties Committee. So when things get to the Court of Justice, it's a very complex process, but the preliminary reference procedure has been the way of which most litigation gets to the court. So there are a very limited number of technical procedural ways in which the effects of a ruling are limited. and it can take a very long time for cases to get to the court. So, these are very profound questions that limit, sensitive areas being developed, and the Court of Justice is notorious for reinterpreting questions and for having a very different type of, it depends on the language of the case. The court increasingly uses less footnotes. The court can reformulate questions that makes the paragraphs a lot shorter and more nuanced. So it can be very difficult to understand the court's reasoning. For example, very interesting cases in passenger name records recently, the court effectively rewriting Belgian law in terms of its answer. So it's a profound constitutional question: what gets the court, why and when? And I would say that the fact that the Parliament has litigated on so few occasions, this is a very damaging or very difficult there's very limited amicus curiae interventions possible in the Court of Justice, and so it's the infrastructure is such as to be quite difficult to understand. And maybe if I can also just turn your question very briefly on its head and say that, well, actually, studying things in the Court of Justice and strategic litigation, to my mind, is also quite difficult, because strategic litigation should be about change, and understanding that change, I would say, is outside the courtroom in the form of lobbying is one other way to consider what is going on in a field. So I'll stop there, but just to say that this is the million-dollar question is part of a vast literature over many decades. Scholars all over the world, particularly brilliant political scientists in North America, and great people such as Sabine has done amazing work on this as well. And especially in an era of soft law, understanding integration through laws is quite a challenge.
Thank you, Elaine. Sabine, a nice opportunity for you to reflect upon this, to enlighten us.
This is probably the most difficult question, in particular in the European context, in the EU context. Why? Because this question of what does the court think, or is the court a political actor, is a literature that has emerged in the United States. And the US Supreme Court has one specificity, that is publishing their rulings and explaining which judge decided what. And this is an information we do not have in the European Union. So therefore, the decisions by the Court of Justice of the European Union are a collective decision, and we have absolutely no way to know what the different judges and how the different judges decided. So therefore, we need to take the court as a collective actor, and this makes, of course, things extremely complicated, because when you have 27 member states represented in the court, which are not represented, but there are 27 judges, and they come from slightly different national backgrounds, then it is very easy to have an overall view and say, well, the court decided this because of. And I think we need to be very careful to come to these conclusions. So now there are different methods to circumvent the fact that, contrary to the US Supreme Court, we don't have this information, and so we have a hard time saying whether the court is a political actor or not. And there are a number of studies. We've talked already about Kelemen and Pavone, but also Blauberger and other colleagues who tried in a very indirect way, because this is the only way they have, or Daniel Noreen, for example, to figure out, compared to, as Elaine said, the environment in which the court acts, so that therefore the positions of the Commission, the member states, or the litigants, to see, the positioning of the court. And it's very hard to come up with general conclusions on that. Nevertheless, I would still insist on the fact that no court, and I'm very careful in framing that now, but no court is an island. So therefore, the court is not only a mouth of the law, which are, floating around without being linked to any other reflection. But to say here, the court is a strategic political actor that always know what the outcome is, I think this is one step too far. So we need to be somewhere in the middle and probably develop more and more solid methods to really measure the political nature of the court.
Thank you very much, Sabine. Giulia, do you think the judges and the establishment overall of the judicial authority, do they want to show to us as little signs of giving us some empirical information about what conclusion would be more reliable? It looks that they try to build the walls of neutrality for the right reasons, of course, we understand, but is there any possibility for us to decode the real or not the real, which one would be more plausible, which of the two extremes the center of gravity moves towards?
Thanks, Oles. This is a very complex question, and I think that Elaine and Sabine have already provided plenty of food for thoughts. What I'm going to say is probably a self-evident point, that it is quite hard to measure law and to measure politics. And this in a way underpins my answer, in the sense that there's a tension, of course, in literature between trying to quantify and make the behavior of actors within the constitutional context measurable, and incommensurability of law, in a way. So while, of course, empirical methods, quantitative methods help us, of course, disentangling the dynamics of constitutional orders, and to enhance even transparency on how these political actors behave. At the same time, I think we're operating in a field which is per se quite unquantifiable, which is the field of law. So I think that this tension will accompany us, so to say, throughout any types of studies, any types of, we can say, attempt at making, first of all, distinguishing law and politics, which is impossible because law is politics in a way. But also we can say this tension also makes it very difficult to create clear-cut categories. But this doesn't mean, of course, that this work and empirical methods that I've applied myself as well in my work cannot contribute towards enhancing transparency. So I think that perhaps rather than, so to say, measuring the behavior of courts, which is quite complex as a challenge, because we need to look at legal reasoning, we need to try to unpack how the courts think, which is quite hard to do. I think that there are so many interesting questions about transparency, about, we can say, legal opinions, dissent, and all of these questions that, for example, for the Court of Justice are very hard to answer because of the lack of transparency when it comes to, for example, dissenting opinion. There are no dissenting opinion in the Court of Justice, but then reflecting numerically and looking perhaps at the background of judges and path dependencies and patterns can help us rethink, so to say, the structures and the dynamics of the court. So I don't think I've clearly answered your question, but I made more a methodological point probably rather than a substantive one.
you know, the views of all three of you are so inspirational and so mind opening, that the questions are less relevant than the answers. They have autonomous, self-sufficient nature, so to say. Thank you very much, Giulia. I think it gives me at least a lot of additional ingredients to my reasoning. Elaine, I propose we revert to your monograph, which has been recently published, and the title of the book is quite self-explanatory. So you're talking about the EU as a global digital actor. So in the context of our conversation, and obviously this is the question also to Sabine and Giulia, we see a new legislative activism in the field of digital, cascade of digital acts, digital economy or digital markets, digital society related acts. And if there is a common denominator in all this catalog of new legislation, we can say that there is an attempt to grant a larger discretionary power to the enforcer, not rely on the invisible hand or atomistic competition, but somehow the wisdom of regulator, qua enforcer, etc. And this leads me to the question, if the legislator in its capacity of direct creator of the law intends to minimize, or not to minimize, maybe to limit the role of judicial authority by granting explicit larger discretionary powers to the enforcers, how far they can go, how far the judicial power would accept such nudging towards being less active, or maybe there is no such signs at all in the latest wave of legislation?
Oh, thanks, Olis. That's another $1 million question. There's a huge difference between the internal and external of EU law, and I would say all the things that you outline, they may, well, you know, one huge example is the EU-US Data Privacy Framework Agreement, where there's an independent court. But in general, in the external or global context, the EU is increasingly signing up to non-binding digital partnerships, and very much entering into, you know, huge swathes of soft economic law, soft law solutions. So all of the things that you outline are, you know, very much the EU's regulatory power. And I think it's interesting questions about whether the Commission has the actual manpower or woman power, person power to enforce all of this legislation, and how much will get to the court. These are very, you know, mind-boggling questions as to the capacity, although the General Court has a huge number of judges with very little work by all accounts. This is not the case of external relations. It's a very different, you know, set of questions. So I would say the assumptions that one adopts are not the same, and the EU has very much piggybacked upon its GDPR superstar power and its you know, the regulatory muscle in doing this. So just in terms of the bandwidth, I think is the guts of your question about, you know, enforcement capacity and how this relates. Does institutionalization breed judicialization is something that I have worked a little bit with Sabine's colleague Fabian Turpin in the past, looking at the US question, looking at third countries. And I would say really the US is a very different breed apart. And so it remains to be seen the effects of all of the legislation that you outline, and how, you know, how the institutional balance question emerges, and the capacity for the court to absorb that. And you know, maybe to take the question back a little bit to maybe Sabine raised this question, or you know, this maybe it was Giulia, I can't remember, that, you know, one basic point is that a lot of EU law is not enforced, right? There's been political agreement in the last number of years not to enforce particularly areas such as, you know, foundational areas of EU law that my students learn the most basic, free movement of goods. And we have a huge question mark about what is the law. We don't even, you know, the Commission cannot take all of the cases, and it is not representative of the case law there. So it's a very important question you raise as to who has the capacity to bring all of this. And we know that in the data era that there's, you know, NGOs do not have the resources of the GAFAMs with 75 billion, whatever turnover, you know, so this is a huge resources question. And so I hope I'm not answering your question I'm very circular because I've only had 1.5 coffees, but certainly there is a huge difference, I would say, as the first answer to your question, that the internal and external do not match, would be my, and I'm sure the others have lots to say on this.
Thanks a lot, Elaine. I think, yeah, the reading of EU as global actor has two dimensions. One more kind of strategic, one is the relationship with other entities, yeah, in field of digital. So Sabine, how do you see this institutional institutional communication and bargaining of power?
Yeah, Elaine is really the specialist of this particular question, and I think her analysis is super relevant. I would say that new fields, the work that we did also with Fabien Terpent and Miriam Hartlab on the issue of soft law shows very much that in fields, in policy fields that are new, that are not regulated, that emerge at the European Union level, and that are particularly technical. Soft law is certainly one of the tools, the instruments that is most used. And I think that the digital the field of digital policy is certainly one where we see this this use of soft law, despite the fact that the European Union has clearly legislated on this issue. With a number of acts, and most recently the IA Act. But still, when we look at the regulation, we realize that how unspecific it is most of the time, and therefore makes soft law emerge even more than in other areas. Now, what is fascinating, and I entirely agree with you, Alice, and with Elaine on that, is to say, in this particular field, the European Union is an international actor. It is an actor. The IA Act has been promoted as the first artificial intelligence regulation worldwide. That groups together such a high number of citizens, of people. But still, what we observe in this context is that the European Union, and now I'm going a little bit beyond the legal question, but the European Union is an actor that has a hard time imposing itself otherwise than as a regulatory power with regards to artificial intelligence. So all the big actors are non-European actors. They're either American or Chinese or Indian, or and so the role the European Union has taken over is a regulatory actor in this field. And still, there's lots of, as Elaine has underlined, soft law out there, probably also because the development is so quick that it is very hard to legislate otherwise than with very general principles.
Thank you very much, Sabine. Giulia, how do you see this institutional setting?
Thanks, Alice, and thanks to Elaine and Sabine. I am no expert in this field in the sense that this is a question more on strategic policy making, and this is not an area where, to say, I've focused my work. I can just give some very brief comments. I think that as an external observer, because I think that if we think about strategic policy making and what you were referring, for example, to in the field of digital markets, the DMA, I think that, of course, now legal frameworks are becoming more complex. We have more law than in the past. Law has proliferated and is covering all sorts of fields. So clearly, this is also an expression of the need to regulate or at least govern some complexities that have emerged from society. Now, moving to the international arena, I think I agree absolutely with Elaine and Sabine. There is a tension between the internal and the external. So how the EU as an actor, as a political actor, operates internally, and how then it conducts its policies externally. I think that a big I was trying to think historically, comparing this question to the strategic litigation one, and it seems to me that the truth is that so strategic policy making probably, but to be tested, has always existed. And I'm thinking about international treaties, international agreements that were struck in the past. This was happening, but I think that what has changed today, of course, is globalization. And the need, of course, to tighten even collaboration on the international sphere, and communication, and in a way also transparency, in the sense that as academics, we're here discussing about the strategic policies of the EU on the international arena, right? So I think that this is, of course, an advancement of governance structures that have become more transparent, of course, to a certain extent, and allow us to better understand also the motivation. And this is, I think, a result probably of good governance principles. And I think on this, the EU has been quite good. But I look towards Elaine to understand whether she would agree or not on this. But I think that because of this transparency, this strategic policymaking has become also more evident, I think.
Thanks a lot, Giulia. I know we are approaching to the end of our conversation. There are a few questions which I wanted to raise. First one concerns your current work. If you deal with issues linked to strategic litigation, or maybe you wanted to introduce to us some new dimensions of this problem or this reality. Another question, so maybe we can choose which one would suit best. I remember we participated at another event, Giulia, and I was really impressed by your presentation where you were talking about the vocabulary of rights and balancing, continuous balancing mechanics, which takes place within the Court of Justice of the European Union and beyond, and the phenomenon of kind of inflation of rights, that each societal interest or each heavyweight player is capable to decode or recode their interest into the vocabulary of human rights, and thus we have different rights competing with each other. We change the vocabulary, but still the interests have to be somehow reconciled. That's the second aspect which I wanted to raise. And also maybe digital constitutionalism, something which we hear often, but not really see in all details different aspects of this emergent subfield of EU law. So maybe any of these issues, if you want to pick up on any of those. Elaine, let's start with you.
Sure, thanks so much. Just very briefly, I'm doing a book project on lawyering, lobbying, and litigating in the transatlantic space as a case study of global governance. I think that strategic litigation suffers from one major flaw. This kind of court-centric perspective doesn't really capture the challenges of the multifaceted nature of public, private interests, of multi-level regulation, of the nature of the space. And I'm having a hard time narrowing down all of these issues, and I know I'm a transatlantic specialist and so on, but I think that there's a unique story to be told about this, and it's very problematic from an EU law perspective to say it's just EU law, that it's just Europe, that it's, you know, when we try to narrow down concretely what's happening. So I would say that the fact that big tech can move, you know, hundreds of millions of consumers, or well, let's say 60 million people in the UK, to California law overnight, or, you know, how we change control, you know, how even in Europe, you know, there's lots of French litigation at the moment about French consumers being put under, you know, California law and US law, so before national enforcement. So, you know, the idea of jurisdiction, I think, is something that we need to be very critical about. Also understanding the massive amounts of lawyers who work in lobbying in the EU, also understanding that litigation is at the end point of a journey and that it has huge limitations that are very expensive and costly and sophisticated. Ordinary people can input into lawmaking much earlier or understand, litigation is really, it's kind of next level, right? So I would say that's the project that I'm doing now. I think you had a question on digital constitutionalism that I find very interesting. I find it's a very Germanic idea, focusing on constitutionalism and public law. I'm not, Germanic. I'm a big fan of everything Germanic. My husband's German, but I was not to be anti. But I say that it's a public authority reading. I think is deeply problematic from an EU law perspective to push, and it also pushes a court-centric view of things. And it's not true that is there a constitutionalism emerging? It's a vast space of rights, and it's a vast space of breaches of rights, and it's a vast space of lawmaking. So I think it's a very beautifully written. I love Gregorio has a fantastic piece on this. I think it's so well done. But do I believe in it? No, I don't. I think it's actually quite wrong. And it's Verfassungsblog, blog. It's a very Germanic school of thought that has pushed this as a view of EU law and digital stuff. I don't criticize. I think they're doing amazing work, but I don't subscribe to that. So I see things as a global governance question first and foremost if you're trying to really identify what has happened. But I don't say I have the answers. I'm not a data protection lawyer. Luckily, there's brilliant people like Giulia and political sciences like Sabine who are able to tell us more about the law in Paris. So there you go. Thank you.
Thank you very much, Elaine. I wanted to add to the plate another aspect for your selection. So Elaine, if you want to comment on this as well. The business of strategic litigation, we see that it's been commercialized, and there are many entities, global entities, who somehow tries to scan the market, search for opportunity to litigate. It's not strategic. They pursue their particularistic interests. If something doesn't fit well into the system, if you want to reflect upon this phenomenon as well, in addition to other issues which I have asked. Sabine, please.
Thank you. Yeah, these are fascinating questions that you have raised, and I would like to pick on two issues. The one would be on the business of strategic litigation and the impact of that on a political system and liberal democracies in general. And the second one I would like to talk about, which is linked, is the digital constitutionalism. With regard to the business of strategic litigation or litigation in general, this asks, of course, a super important question, that is, where do rules come from? Okay. So if the rules are not decided any longer by elected decision makers in the context of parliaments, and this is probably also one of the reasons that Elaine pointed out earlier, that the European Parliament is a very careful litigator, meaning that it doesn't litigate a lot. Which is linked to the fact that the definition of decision making and the definition of rule making is based on democratic politics. And if we take that out, and if we only focus on, or if we only see that rules are made through strategic litigation or the business of strategic litigation, then of course we might have a problem at one point of democratic legitimacy, which is the very similar one that we have when we look at soft law very often. So this is the first answer. And the second, with regard to digital constitutionalism, I think for me, and I'm probably exaggerating, but the revolution of artificial intelligence is for me an absolute mind-blowing process that takes place now, which will change the way we do politics. It will change how we look at law. And brings me back to a question that was raised just 10 days ago by a colleague in another conference, a legal scholar, that asked the question, well, is artificial intelligence now a policy entrepreneur? Do we need to take it as an individual actor, something we've never seen before, but which influences the way we make politics, we decide, the way we make democratic decisions? And this really, I think, is one of the central questions we need to ask ourselves. And there were fantastic research coming out, and Elaine, of course, is one of the main proponents of this research. So I thank you.
Giulia, the floor is yours.
Thank you. We have discussed so many issues, right? So I really don't know which one to pick, because they're all fascinating and very interesting, and it's great to listen from all of you, really, and learning and reflecting on the connections between all these issues, because I totally sympathize with Elaine struggle in connecting the dots, because I agree that clearly there are connections between strategic litigation, strategic policy making, of course, and global governance and trends and global trends of policy making, and I would say also institutionalization of policies that are taking place across the world. So it is very complex, and I also think that there are questions of legitimacy and how should we try to unpack this phenomena? What kind of labels do we need? What kind of epistemological tools we need to try to decipher what is happening on the ground? And I think that digital constitutionalism is trying to do that, and I think that depending on how we look at it, of course, we can certainly distill some interesting dynamics. Essentially, the role of courts in a context of relatively limited legislation in the digital field, with, of course, now the landscape completely changed because of the plethora of different instruments, for example, adopted in the EU. So I think these are very complex questions, and from my perspective, what I'm really interested in is how fundamental rights really play out in these dynamics, and what is their added value, what is their effectiveness even in trying to solve these tensions, or maybe creating these tensions. And I'm also very interested in how the state more in general, and in particular courts, are both we can say actor, but also reactors to these dynamics, right? In the sense that all political actors, including courts, have, of course, the ability to exercise their powers, their constitutional powers, but at the same time, when it comes to digitization, they're also users of this technology, in the sense that the state is becoming increasingly digitized. Think about automated decision-making for administrative decisions, or courts that increasingly are embedding within their structures digital tools and elements. So I'm really interested in how these dynamics are reshaping the relationship between the individual and the state, and the dependencies, the techno dependencies that are emerging as a result of digitization. Because I agree with Sabine as well. This is many, so to say, underscore the fact that, well, this is a technological development. We've had many developments in the past, also grounded in technology. I think that the scale of this transformation is quite different. So it's important to so to say, bear in mind the politics of these technological developments.
Yeah, amazing. I think we spent really a fantastic hour today in given our own research visions and positions, intuitions on different, analyzing this phenomenon from different perspectives. I learned a lot, but we have this tradition to end conversation with offering recommendation to the next generation of people who will be examining this and similar issues. So Elaine, why wouldn't we start with you offering some recommendations to students? This can be related to the selecting the topic, or maybe some learning techniques, how you balance your work, leisure, protocols, or anything which you think would be useful for them to learn at this point.
Oh gosh, that sounds fantastic. Well, more substantially related to work, I think the next generation, and I know they're already doing, is to look outside your field and your subject. You know, you'll learn so much from other fields and subjects. Law has a very narrow take on things, so you know, continue to work with other disciplines and to study more. But I think that's normalized in the next generation, and I think that's fantastic. It will be very rich. I advise you all not to work very hard and to have a sport or a hobby or an activity that takes you away from desks and computers. I spend lots of time in London rowing on the Thames, rowing very badly, but I enjoy very much not having any access to computers or being at a desk. We live a very difficult life, so make sure to look after yourself and enjoy nature, and yeah, make friends with other people. Don't be friends with just other academics. Yeah, have a more, but it's easier to say. So thank you, Olis, for all of for even asking these questions. It's a very nice thing for future scholars. Good luck to you all, is also what I'd say.
Thank you very much, Elaine. Sabine?
This is a very nice way to end a meeting. And I would say for future generations, work hard, as did say Elaine, but be passionate about what you do. Be curious and try to find you know, questions and new answers. Remain open, question yourselves systematically. Don't be too sure of what you find, and come back to these conclusions regularly with lots of methodological rigor, I would add. And to end, how do I balance my work, as we all do, leisure time? I think nature has become so incredibly important. Nature linked to culture, but one doesn't go without another. And if we don't have this space where we can, you know, get free of our computers and of our worries, then I think we have difficulties. Thanks a lot.
Thanks a lot, Sabine. Giulia?
Thanks, Olis. I mean, this feels like a big task, you know, thinking about the future. I mean, first of all, I think that we live in a society where there is a push towards ticking the box of the push towards demonstrating that we have met certain requirements and we fit, so to say. I think that the truth is that the real fun, but also the real discoveries, I think, might happen when we're not too preoccupied about ticking the box and so to say conforming to what we think should be the norm and the rule. So I think that, and I'm saying this just to invite future scholars, students, to be creative, to be open, and to realize that some things that you have studied that you thought you would never use in your life actually could become your work, your passion. So just be mindful that all learning experience are helpful, even more in the long term. You will be able to connect the dots the longer you keep working and further down the line. And how to balance work with, so to say, well-being. I am a big fan of yoga, so I do yoga, and I think it's a great practice, and I really enjoyed And my colleagues make fun of me because they say, oh, I see you, you know, you go to yoga and then that's where you get the best ideas for your papers, right? So I mean, it's a joke, of course, but maybe it's not a total joke. Just to say that, of course, if you need to be in balance with yourself, you need to be careful about your health, and this is also what will help you to work at the highest levels as well.
Thank you very much, Giulia. These were 3 fascinating recommendations. Really hard to add anything, and it was really an amazing opportunity for me to learn from all 3 of you: Elaine Fahey, Sabine Saurugger, Giulia Gentile. Many thanks indeed for this amazing hour. It was a pleasure to see you all.
Thank you.
Thank you so much, Oles.
Thank you so much.